Howdy, my name is J.D. Foster. I'm an attorney here in Waxahachie, Texas. Today I want to take a moment to talk about lease-to-own agreements, particularly in relationship to real property. They're commonly referred to as executory contracts or executive contracts, lease-to-own agreements, rent-to-own agreements, these types of things. In either case, they're primarily covered by Chapter 5 of the Texas Property Code. And over the course of my career, I've had the opportunity to deal with quite a few of these different situations on both sides, both representing tenants or land purchasers and landlords or sellers, depending on how you choose to use your nomenclature in this situation. And that's precisely the issue with this code section and how people tend to fall into it. I'd say the vast majority of people who wind up in lawsuits relating to Chapter 5 of the Texas Property Code and executory contracts didn't even know that that's what they were going to fall into. On the tenant side, it tends to come up in urgent situations such as eviction suits, foreclosures, these types of things. And at times, the tenants didn't even understand their rights or what was going on or what they may have been entitled to. On the landlord side, I have, of course, represented landlords who are being sued under these code sections, landlords who are attempting to remove tenants who perhaps haven't been paying on a monthly or whatever their scheduled basis is, or have perhaps damaged the property or not abided by the agreement in some material fashion. The tricky thing about these lawsuits is that the way the legislature has written this, it leaves everybody in sort of a dual nature. You're both a tenant and a landowner. What is clear is that the legislature is effectively attempting to treat a lot of these contracts as if the tenant has a right to record title. And indeed, some of the code sections seem to directly address that specific issue. What I have found is that whether you be a landlord or a tenant in these cases can get fairly technical in terms of the substantive law involved. And it can be difficult to understand what sorts of obligations you may have as a landlord in terms of annual notices, initial notices, what kinds of things you can and can't have in your agreement, how to remove tenants. On tenant's side, understanding what you're entitled to and when you may be entitled to it. The list goes on for quite some time because, as I said, it can get somewhat technical. In either case, whether you're a landlord or a tenant facing a lawsuit such as an eviction, a foreclosure, a civil litigation lawsuit involving these code sections, or you're simply contemplating entering into an agreement relating to one of these types of things, I strongly recommend you consult with an attorney. And of course, my office is available to assist people. We would encourage you to give us a call at 972-937-1616 so that we can evaluate your case and see what we might be able to do to help you either A, avoid the pitfalls or navigate the minefield you may have found yourself in the middle of. Thank you.